Thank you very much. Today we're going to start. We have a few bills. Our first bill of the day is House Bill 180. Delegate Ken Kerr, a bill that we are all extraordinarily interested in hearing about. It's State Board of Cosmetologists License Lashes Extensions. I guess we're going to regulate the length of the lashes from now on, which I think many people agree with. So I'd love to hear your bill. So, and I take it you do have a panel? Outstanding. Okay, so if you, Mr. Kerr, if you'd like to go ahead, delegate, and then we'll get going. Need to roll.
Today, I'm Delegate Ken Kerr. I'm here presenting House Bill 180, State Board of Cosmetologists Licensing Eyelash Extensions. So it's easy to have fun with a bill like this. But as we learned as children, it's all fun and games, then somebody loses an eye. So what we're talking about today is trying to put some safety guardrails around the practice of eyelash extension. And there are injuries that can range from chemical burns to having the eye injured with tweezers, to allergic reactions, scratched corneas, glaucoma, infection, and in very rare cases, blindness. So I would like to turn it over now to an expert. So let me just state your name.
Good afternoon, Mr. Chairman and members of the committee. My name is Crystal Moore. I am in favor with amendments HB 180, but I do have an amendment that I would like to speak about. I've been a eyelash extension technician for 18 years. And while I am aware that there are, in the state of Maryland, experts that have been practicing for a long time, there are eyelash extension technicians who have not. And they do have errors. Now, with that said, I'm looking for a grandfather clause with this. In 2006, I trained with Jo Maselli of Extreme Lashes. She is the founder and creator of these said lashes. I am a small business owner in Baltimore County. And I've seen some work that has not been the best, but with that said, I do expect that you understand that for those of us who have been experienced for 18 years, if we can have a grandfather clause for 15 or more years, that would be great. With this, I would urge your consideration in the grandfather clause, provide an exclusion for certified lash techs who have been actively engaged in 15 or more years, and that allow them to operate their business in a commercially leased space, exempt from the requirements of a licensed beauty salon as requested for this bill, though. Thank you.
Thank you very much. Before we go on, if there are no questions, I do have a question. Delegate Kerr, you were very brief in your explanation. Could you tell us what the bill does?
The bill will regulate eyelash extensions, similar to other cosmetology, that you will have to apprentice essentially under a master beautician or someone who is already credentialed by the Board of Cosmetology for a specified number of hours in the bill.
That's fine. I just wanted to make sure that, and are you in agreement with the young lady who's on your panel? I'm assuming that you do want the grandfather clause in, or is that something that you're discussing?
We're in discussions over the amendment, but I did want Ms. Moore to come up because obviously she knows more about this than I do. So we'll continue to discuss the amendment, and I will let the committee know when we have resolved that.
And I say this, as you've heard many times, is any delay makes it much more difficult for bills to get through. Obviously, it's going to be in subcommittee. It doesn't sound that complex, but we want to give you the time to figure out what you want to do with the amendment, but I would also, as you well know, once you pass the bill over to us, it's ours. So please make sure you discuss the merits of what you want to do with this bill, okay?
Okay, would just like to add, Mr. Chairman, that this bill was heard in the Senate last year, passed the Senate 47-0, and but
You
did
know
not have a
that-
cross file.
You know that makes it a lot harder to pass in the House. You got to learn to lead the right way, buddy. That was definitely not, you're
Okay,
doing so well.
can I request you strike that? from
There you
the-
go. Thank you very much.
Thank you.
I appreciate it. And we'll call our next panel. Thank you. Oh, wait there. You didn't get to escape. Delegate Rose.
Thank you, Mr. Chair. Delegate Kerr, have you had this procedure ever done yourself?
Delegate, I'm so glad you asked that question. You see, I had it done and I was injured.
Thank you for your very serious question, Delegate. Again, guys, thank you very much. Oh, wait. Okay. I knew this wasn't going to go away quick.
No.
Delegate Weibel.
Thank you, Mr. Chairman. I'm not going to ask you about your personal beauty habits. So anyhow, is there a fee proposed? Because I don't see one in the bill.
There's not one in the bill, no.
All right. So would that be done by regulation?
That's my understanding. The Board of Cosmetology is the one that we consulted with to have the training requirements put into the bill. And I don't believe there's a fee included.
So you require 60 hours of instruction in a cosmetology school approved by State Department of Education or MHEC. I assume those programs already exist. Where did you come up with the 60 hours? Is that an established practice already?
I don't know. Perhaps Ms. Moore does.
I do not have a cosmetology license. I was certified by Extreme Lashes. So I don't know those
Okay.
answers.
Okay, we can get you that information, Delegate.
Great. Thank you.
Thank you for your legitimate question. We would now move on. We will now move on. Oh, wait, I'm so sorry, birthday girl. No, go ahead. You have a
Ask this
question.
question a little later. It's just
You can ask it now.
it's I'm trying to understand because I know about these lashes, okay? And so are you saying that the stores that the shops that you go in to get these lashes, okay, they have to have so many hours of they got to be certified, they have to go to class? What are you saying, these people? Because in my shop where I go get my lashes, y'all see these pretty lashes, don't you? They only have 2 people in their shop that will do lashes.
Mhm.
So now you have made me cautious that if this bill passed, I want to see a license, a certificate on the wall that they are certified to do my lashes, because I have never looked.
No, I don't think you have ever looked. This, but the way I understand it. Oh,
Oh, I'm sorry.
that you can either take the class or learn under someone who is already certified. And happy birthday.
I knew this was gonna go this way, guys. I
Yeah.
apologize.
May I be excused, Mr. Chairman?
Thank you very much, sir. You may be excused. Yeah, Fisher wasn't even here. Okay, next we have, it says Ann Rouse. Maryland General Assembly, so we have Aaron White, or Arn, A-R-N-E, White. Favor with amendments? And we do have one favor with amendment online, so ma'am, if you'd like to go ahead, starting with your name.
Arne Sosin White. So I wrote it out just because I knew that I would get fumbled. But essentially, I'm here to represent licensed professionals of Maryland, specifically as it relates to eyelash extensions. I've been in the industry for about 7 years. I became a licensed esthetician back in 2019. And over the course of my career, I have seen some pretty horrendous things regarding eyelash extensions. Sorry. Whew, I ran here. So, you know, in my commitment to raising awareness about the risks that are associated with receiving these services from unlicensed professionals, I've dedicated my whole platform, my business, my social media, any way that I communicate with people in this industry, to bringing light and understanding to the benefits and also lessening the risk to consumers by regulating lash extensions. Even as of recent, I know a lot of you may not be aware of lash extensions, but there are many risks that exist within this profession. A lot of them are blindness, a lot of them are eye infections, lash mites, and just many other things that you know, just a quick Google search will show you. But as of recent, I've been apprised of a practice that's happening within the lash industry that includes putting Flonase on the eyelids. Flonase, we know, is an intranasal steroid. It is not meant for the eyes. However, unlicensed professionals are now doing things as such to revert allergies that are associated with the ingredients in lash glue, by going to these extremes. So I'm here and I implore you guys to really hear these licensed okay, thank you. To hear us licensed professionals out as it relates to this, because as things continue to be unregulated, especially when our partnering districts of, you know, DC and Commonwealth of Virginia are licensed, people are now flooding Maryland in order to be able to practice this without regulations. Without the regulations, it's leaving the floor open to them doing anything and everything as a result of greed, and really just as a result of greed. So I implore you guys to really hear us licensed professionals out, the ones that have taken the time to be educated, and, you know, provide these services safely to our consumers, and consider this.
Thank you very much, ma'am. Ma'am, you're here as favorable with amendments. What was your amendment? Were you agreeing with the amendment of the young lady? You have a different one?
Yeah, so the amendment, it is my understanding that this was being proposed that cosmetologists could also do this. However, I feel very strongly about the fact that this is an esthetician-based service, just because we have extensive education and knowledge just about the whole anatomy, where cosmetologists don't have that same level of teachings during there. So the amendments are that it be specific to estheticians, unless there's something proposed that could give cosmetologists in this situation a more, you know, advanced teaching to be able to render these services.
Thank you very much, ma'am. See no further questions. Let's go on to we have our virtual. Ms. Moore. I'm sorry, Ms. Nicole Fletcher.
Good afternoon, Economic Matters Committee. My name is Nicole Fletcher. I'm the Executive Director of the Maryland Board of Cosmetologists. I am coming to you in support of this bill, favorable with amendments, of course. The board supports this bill, House Bill 180, with amendments suggested by Delegate Kerr. The board feels that this new limited license to provide eyelash extensions will add value to the cosmetology industry. Our just one amendment, which it seems like most of you who testified are in agreement with, is about adding limited estheticians to this bill. As Ms. Moore stated earlier, many of our estheticians are already in this industry working and providing this service. that they do not need a license for as of yet. To answer a question that I heard earlier, they would be required to have a license now. So I heard a delegate mention that you are receiving the eyelash services now. As of right now, they don't have to have anything posted in their salon, wherever you are getting your services. That is not a requirement. When this bill becomes effective and we get our training, our curriculum, all that stuff in place to divvy this legislation out to the schools, then at that time, we'll have to come up with a grace period of some sort. But we will then require them to have a license posted. So again, my testimony is to add licensed limited estheticians to this bill, which is similar to what Ms. Moore says, as grandfathering them into the license. Thank you. I welcome any questions. It seems like we had a few earlier.
Well, it looks like we have none now. So thank you very much for your testimony. I believe that does conclude this bill hearing. Again, thank you guys for everyone who's listening. We're on to the next bill now, which is House Bill 211. Delegate Taveras.
I'm here to make it easier for you. Thank you, everybody. Thank you, Mr. Chair. And everyone, thank you for allowing me to come before you today. It's an honor to be here. I am here to ask for your favorable report on 211, business regulation. This bill prohibits general contractors, brokers, and subcontractors convicted of wage theft in any state that they'll be banned from doing business in the state of Maryland for 5 years. In 2019 alone, immigrants made up 66% of all workers in the construction industry. And as we know, immigrants and low-skilled workers are often low-wage and essential workers. This bill is a crucial step towards addressing a widespread and detrimental issue that affects countless of workers in our state, with over $20 million in wage theft claims since 2009 and an average of $64 stolen weekly from each worker. The scope of this problem is alarming. This practice is essentially prevalent in low-wage jobs, disproportionately impacting immigrants, people of color, and women. This bill aims to safeguard these vulnerable groups from exploitation while ensuring that Marylanders remains a state where fair labor practices are the norm. The passage of this bill is essential for promoting fair competition within our business environment, allowing companies that have engaged in wage theft to operate freely in Maryland creates an uneven playing field, giving a disproportionate advantage to giving it a disadvantage to businesses that are not law-abiding. This bill seeks to level that playing field, ensuring that all businesses operate under the same set of ethical standards. Therefore, the need for HB 2011 is clear. So I ask for this committee to provide a favorable report on this bill, and let's protect the most vulnerable of workers. Thank you. Any questions?
Delegate Taveras, I do have a question. And I don't have the bill in front of me, so I apologize. You said convicted. Does that mean we're criminal, something criminal is taken out, or is it that there is a civil finding?
No, that this has to be a deliberate malfeasance that is committed as described by the law.
I understand. I'm sorry, I'm reading it now. So basically, so in Maryland, if somebody was found to, committed wage fraud, but not convicted, this would not apply to them. Only those, so it sounds like either very egregious cases or cases that fall under federal law.
Yes, sir.
All right. And do you know right now, in Maryland, are there individuals operating that have been convicted and basically are, because this law is in effect, are still operating in the state?
We reached out to Dollar to try to find out, and we're still waiting for a response.
And so, all right, because it would be good to know what it is we're talking about here. And again, I do understand the spirit of the law. Just want to make sure in pushing forward that we're addressing it properly. So thank you very much.
Yeah.
Delegate Weibel.
Thank you, Mr. Chairman. Could you clarify for me, your testimony referred just to wage theft, but the bill says criminal malfeasance, misfeasance, or non-feasance. I assume that's much broader than wage theft?
Well, I brought it with the intent of honing in on wage theft, but the drafter formulated it in the sense of a more, I guess, stringent, more per the law. That's my understanding. I'm not a lawyer. I'm a scientist.
I understand. Thank you.
Thank you very much, good delegate. I do not see any other questions. So, and I believe that there's nobody testifying against your bill, so we'll move on. Thank you very much, ma'am.
Thank you. Appreciate you.
Last bill of the day is our own Delegate Harrison. House Bill 175.
Mr. Chairman, bring up my panel.
You may begin, ma'am.
Thank you all so much. For the record, I am Delegate Andrea Fletcher Harrison, and I am here this afternoon to present HB 175, Occupational Licensing and Certification, and it has another longer title. Colleagues, in your packet, my written testimony is listed under Vernita Johnson, so you can look at that. I'm not going to read it because I'm not going to insult your intelligence. What I want to do is just talk a little bit about what this bill is and what it is not. This bill is simply a presentation or a request for individuals who may have had a former infraction to ask for a predetermination if their former infraction would prohibit them from getting a license, an occupational license. So in other words, let's not waste my time or money if at the end I'm never going to be able to get this license due to whatever may have been in my past. So this is not saying that there cannot be a background check. It is only asking for a predetermination prior to spending my time and money to go to a class, take an exam, and maybe even pass that exam, only to find out that I won't be able to get that license. So I think that there is some misinformation about this bill based on some of the testimony that I saw in our system. As I said, it doesn't stop you from doing a background check if the job or the occupation requires a background check. You will still be able to do that. Each person, they must complete whatever classes, take whatever exams are necessary for this. They don't get exempt from anything. They're only asking upfront if they would be prohibited from getting a license. And I want to keep repeating that because we're not asking for anything special. We're just asking for predetermination. With that, because I have had the opportunity to speak with some of the groups and I have read some of their testimony, I have offered 2 amendments. They will be coming to the committee directly. The first one, it exempts the public safety and correctional services. And the reason that I put that exemption in is because in state code under state personnel, that particular group is exempted from the requirement as it relates to background check. So if they need a background check for that, that will continue on. The second amendment that I have put in addresses the individuals from the nursing industry. Their concern was that they have a compact of some sort, and of course, I won't be able to find the exact name of it while I'm looking for it. But because there are 27 other states that have already passed this, one of the latest ones, South Dakota, has put in their code, in which I'm offering as an amendment, that nothing in this chapter may be construed to override, supersede, invalidate any compact or agreement already in place with regard to the regulation of any profession or occupation. Further, nothing in this chapter may be construed to supersede any authority for an agency to require an applicant or a licensee to submit to a background check. So as I said, it is not stopping anyone from doing a background check. All we're doing is asking for the opportunity to know upfront whether or not they would be eligible or ineligible to receive an occupational license. And so with that, I am asking my good friends, all of you on this wonderful committee, for a favorable report on HB 175. I think, wait for the light to come on. Don't push it. It'll come. There you go.
Good afternoon, panel. My name is David Morgan with Reason Foundation. Thank you, Mr. Chair and esteemed committee, for the opportunity to speak in support of this measure. First thing, a couple things I want to mention is that United States Chamber of Commerce said that there's a severe shortage, labor shortage in the following areas in the state of Maryland: healthcare industry, manufacturing, HVAC, electricians, and plumbers. That comes from the United States Chamber of Commerce. As it relates to occupational licensing, there are some things that Maryland has already done really well. And I'll quickly outline those 5 things: juvenile adjudication, hard and seal expunge convictions, direct relationship, individualized consideration, and older offenses. The state has enacted that, and that is to be commended. As Delegate Harrison said, pre-qualification, finding out on the front end if you're disqualified before you take the time, energy, effort, and money to try to seek a license. 4 other areas where we think the law can be improved. First, arrest only. If you're arrested, but you're not convicted, a licensing body cannot use that in terms of your determination. Vague terms. A licensing body could not use vague terms such as lack of moral character. That's very subjective and it might leave the applicant confused in terms of why they were denied. The other 2 things: written notice. If you're denied, you're getting written notice as to why. And finally, notice of rights. If you are denied, what are my rights in terms of the appeals process, rehearing, and reapplication? Those are 5 common sense things that we think can be done in the state of Maryland to continue the progress that's already been made. Thank you, Mr. Chair, and the rest of the committee.
My name is Chad Reese. I'm with the Institute for Justice. And for over 30 years, the Institute for Justice has worked in the realm of protecting entrepreneurs' right to earn an honest living. And much of that research has been in the realm of occupational licensure. I've included a lot of links to those reports, including some Maryland-specific research and information in my written testimony. For my oral remarks today, I'd just like to focus in on the pre-application process that's been mentioned so far. And I'd like to address 2 common rebuttals or concerns that often are associated with that pre-application process, and assure the committee that I don't think, especially as presented in this bill, you need to worry about. So the first is the concern that this would somehow create additional administrative burden or challenges for a licensing board or agency. I would just remind the committee that right now, to the extent that those challenges exist, they are borne entirely by the potential applicant. That is someone already trying to get back on their feet and enter a trade after having been incarcerated at some point. And to the extent that there are any challenges in administering a program like this, although more than 20 states have something like this process, that process should be borne by the licensing board as they're making their determination. The other and perhaps more important issue that I want to raise is the common concern that this would actually encourage licensing boards to deny more applicants in a pre-approval process because they're not sure about other information that might come to light. I would just suggest you refer back to the language of the bill itself, which makes very clear that licensing boards can still offer remedial advice, such as taking classes to deal with substance abuse issues. If they believe that there might be a reason for denial, they can include those again in that written pre-approval decision. So again, I want to emphasize that the costs of choosing to try to enter a profession without knowing whether or not your criminal background would bar you from it equate to hundreds or thousands of dollars in fees and tests and possibly years of pursuing the wrong education. So the benefits to licensees, and as David mentioned, to the state of Maryland's economy and small businesses looking to hire these folks would be tremendous.
Good afternoon, Mr. Chair and members of the committee. My name is Cam Bridges, and I'm the Senior Public Policy Advocate for Job Opportunities Task Force, a nonprofit organization that helps low-wage workers gain access to higher-paying jobs. So JOTF supports this legislation because we work almost exclusively with low-income individuals, and we're very familiar with how it is for them to get gainful employment. So there are almost 240 professions that require professional licenses in Maryland. And according to an Institute for Justice report, 60% of low-income occupations require an occupational license. We should be seeing formerly incarcerated people applying for these jobs, but from 2014 to 2018, only 0.13% of licensed applications in Maryland had a criminal record. That's 803 people out of 610,000 applicants. We need to make these jobs more accessible to our most vulnerable populations, but without eschewing public safety to do so. The bill as written allows the board to deny a license if there is a direct and substantial threat to public safety or specific individuals or property. We will still want the licensing boards to be able to do their jobs and allow for safe work environments in their industries, but we also want to make sure that people who are not threats to public safety aren't left out in doing so. JLTF asks for a favorable report to this legislation, and thank you for your time.
All right, I'll close this out. So Christopher Dews, representing the Center for Urban Families. Just wanted to quickly highlight, as the gentleman from the Institute of Justice said, Bureau of Labor Statistics, 25% on a national level, 25% of these jobs that exist right now require a license, okay? I also just want to quickly highlight with regards to criminal records, just so we have some scope here. According to the Bureau of Justice Statistics in the state of Maryland alone, 25% of working age adults have something that would appear on a routine background check. We already have protections in place, as Mr. Morgan mentioned. This is just taking not even a huge step, but a small step forward to ensure that individuals who are returning from incarceration, who disproportionately end up in jobs that do require a license or try to get into their own businesses for themselves, be it hairstylist or barber or carpentry, plumbing, electrical, as the gentleman mentioned when it came to JOTF, like those individuals, they're going to need their license. And I just want to highlight one more time what our sponsor said. This does not change anything with regards to a background check. So it's not as if you secure the license and then a job is automatically given to you. You still have to pass through the background check and all the rest of the formalities that come with employment. So this is simply allowing an individual to have the license so that they can, start the process of moving their step forward. Having a record, it's bad for housing, as we have sponsors here for other bills to highlight. It's bad for financing. It's bad for just trying to secure a license, employment. So this is just one way that we're moving forward to just allowing a more equitable returning citizen population who can secure employment for themselves. That's all. Urge a favorable report. Thank you.
Well, see no questions. Wait, am I going crazy? So, and Delegate Harrison, before we get going, I guess I understand. I see there's a lot of unfavorables, and I'm sure we're going to, discuss some of this. I guess I wanted to question, gentlemen on the far end. You stated access for these jobs for our most vulnerable populations. Who are you referring to?
So that's incarcerated or formerly incarcerated individuals who are returning into society.
That was a very interesting way of putting it. I think a lot of people may disagree with that statement. I just didn't, because I thought the vulnerable populations were the elderly, the kids, the sickly, the people that we're trying to protect, and that's why these laws were indeed in effect. And I just wanted to make that clarification is obviously, you know, people make mistakes. I'm a defense attorney, but I do also understand that the vulnerable populations tend to be those individuals who themselves are victims of anything from crime, you know, disease, things of that nature, including age, no offense to you. So I just wanted to make that clarification that the reason that the law is currently in effect, and I believe the good delegate understands this, is because we're trying to protect our most vulnerable citizens. And I was a little taken back when you referred to individuals coming out of jail as a vulnerable population. Because I would disagree, and I'm not disagreeing with the stance on this bill at all. Because I do believe, to my understanding, this bill is merely saying, hey, let me know before I apply if I'm not going to qualify. So basically kind of doing a background check before they get involved, correct?
I think it was just a poor choice of words.
No question. I just want to clarify because there are people listening, there are people on Zoom as well. But I wanted to make sure for everybody's understanding that our goal is protect the vulnerable, you know, from criminals and individuals. Unfortunately, you know, you're typecast and you are basically an amalgamation of your past. So it's incumbent upon, you know, nursing homes, hospitals, people that install security systems to make sure that the individuals that they're dealing with don't have a criminal past that they may be so inclined to do so again. But I want to make it very clear, and I don't know what the unfavorables are going to be. We're going to try and work through it. But that was my goal. It wasn't to really change the qualifications, correct?
That's correct. And in the bill itself, it says that pretty much an individual would not even be eligible for a license if it is in direct and substantial threat to public safety or specific individuals or property. So I think that may
Isn't that
cover.
already law though? That's what I was asking. I thought that was already the policy, which was the rationale behind.
It was just reworded.
No question. Again,
It was
I'm just trying to
reworded.
make sure that for everybody listening, including those that listen public, that you're not intending to weaken the standards for each license. I heard a mix of things. It sounds like some people are saying that we should remove some of these barriers for individuals. And like you said, so is it also in there about an amendment process? Is that part of your bill, ma'am?
If an individual has been denied or could be denied, then the department should provide a reason so that that individual would have an opportunity to remediate if necessary.
No question. Might not even be the same person, right? Might be a different, you know, CT Wilson. So I understand that as well. But I want to know, is this a court process or was this just, like you said, providing information and giving an opportunity?
That's correct. It is not a court process.
All right. And sorry, you look like you had.
Yeah, no, just want to say, Mr. Chair, first of all, totally agree with everything you said. I do want to highlight, with regards to the words vulnerable, just to be totally transparent. Because of the way our criminal statutes are, and this is more of a conversation that happens often in judiciary, there are many individuals who have non-convictions, but for things like the unit rule, for example, these things will be used against them, even though they were not found guilty. So, like I said, it's a rather shocking number, according to the Bureau of Justice Statistics, that 25% of working age mail-unders have something that would come up. What's even, I guess, more shocking is that a lot of those charges are non-convictions, and unfortunately, many of those non-convictions still come up in a routine background check. And so those things can be monitored. So, and that's simply what, at least when we're using the term vulnerable, like we're not saying, to be clear, and I'm with you entirely. I just want to be clear that, you know, not every single person who has a record that would appear from acquittals to dismissals.
Sure. Or
yeah, that's I just want to make sure.
No, I just was confused by the vulnerable. And I do understand that just because you have an arrest record, that doesn't mean you have a guilty conviction.
Yes. And
depending on who you are, that may be held against you. Totally understand. I'm sure we can work through it.
We appreciate your clarification, sir, on the word vulnerable.
Thank you. Thank you. Delegate Arentz, I'm sorry, I can see you now. Go ahead.
Thank you. I can see you too. I just, the gentleman on the far left, you mentioned something, non-conviction. Could that be a PBJ?
Technically, yes, that does count. However, and I want to say in the bill, the specific language is a deferred adjudication, which is not always a probation before judgment, but it could be interpreted to mean that as well, because probation before judgments are still technically considered a non-conviction. But
You're saying we still include those, which
to
I
be
think
specific,
might be a good idea personally. But the PBJ to include that'd be something I'd be looking at. But the
yes,
plea deals and stuff like that.
yes.
Okay, that wasn't my original question. My original, I appreciate the response to that. My original question, how would this work? If I had a record and I wanted to go into one of these jobs and I want to look at, how do I do that? I mean, what would be the process?
You want to see the process? Yes, so the process would be I would go to the licensing agency that I want to get licensed. And there, I'm there to say, okay, what does it take for me to say, I want to be a HVAC? I want to go into that particular role. What does it take for me to do those things? And as Delegate Harrison said, what we want to add is not only what does it take, but do I qualify? Because if you just tell me what it takes, I do it, and it comes, well, you were going to be disqualified on the front end, then that's a waste of everybody's time, energy, effort, and money. So you go to the licensing entity, I find out what I need to do, I check all those boxes, and then I have a license. Now I can go out and seek gainful employment.
So that the licensing agent, the Department of Labor for all intents, right?
Well, it's different licensing bodies. I don't know if the licensing bodies fall in Maryland, under the Department of Labor or not, but you go to that particular licensing body.
Okay, thanks for that. Appreciate it.
Thank you, Mr. Chair, and thank you, Delegate Harrison. I can completely appreciate the intent of the bill, but in looking at the long list of unfavorables, I'm just wondering how, in practical terms, the employers can make this work, even if they want to be more inviting and welcoming to formerly incarcerated individuals, for example. So I just wonder if, in your process of evaluating the merit of this bill, did you consult with these industries to see how it could actually play out in real life?
And that is why there have been a couple of amendments that I have put in for that very reason, specifically the nurses and public safety and corrections. The others, from what I saw in the testimony, when I read their testimony, they're really talking about what happens afterwards. So for instance, I'm an insurance broker. I had to go through and I had to take, the classes, I had to take the tests. When I went to apply for my license, then I had to answer some questions, basically background check questions. Had I had a conviction that was listed on there, then I would have to give more of an explanation. If by chance I had a prior conviction of I don't know, I'm going to say money wire fraud or something like that, something that has to deal with public trust and money. There's a very high possibility that I would never qualify for such a license if I were trying to be a mortgage broker or something. I would not qualify because there's a breach of trust with people's money. So this is saying on the front end, would I even be eligible to do this, regardless of whether I took the classes and passed, got the license, passed the test for the license. And I think that that's where a lot of the misinformation is based on what I was reading in the testimony. It appears as though most of them are saying, well, we need to have a background check. And this does not preclude you from having a background check. All this is saying is, before I even walk down this road, is it going to be worth it? And that is simply all the bill is saying. Do I need to waste my time, waste my money, waste your time walking down this road? That's the way that I'm reading most of the unfavorable testimony.
So it's not true that this bill would prohibit departments listed here from requiring an applicant for an occupational license or certificate to disclose the following as part of the application, which is deferred adjudication, participation in a diversion program, an arrest record, a conviction of a misdemeanor, a conviction of this and that, or violent crime. So that's not part of the bill?
The bill says that they would not be required to do that if 3 years have passed since the end of their infraction, since they've served their probation, whatever it is. They don't have to disclose that. However, what I would say is that during if they choose not to disclose it and it's something that's in their background that could have, it's going to come out in a background check and then they would be disqualified if it's related to that. So, you know, you either going to check on the front end or the back end is the way that I see it, you know, and this is trying to check on the front end so that we're not wasting anyone's time. If I knew that I had something in my background, if I would use the wire fraud, the money wire fraud thing, and I decide that I want to be a mortgage broker where I have to handle somebody's money, securities or whatever the case may be. If I knew that I had that, regardless of how many years had passed, it's going to come up on a background check. And if I choose not to disclose it, then that's going to be on me that I don't get it. But for an individual who may have had, you know, something that was expunged or pardoned or whatever the case may be, they shouldn't have to be, you know, this time has passed. They shouldn't have to disclose that.
Thank you.
You're welcome.
And for clarity, it's not the businesses themselves who are going to deal with this, correct? It's a licensing agency, correct?
That's correct.
So the business and the hiring people that are not going to, they're not going to be the ones who this is going to intrude upon. It will actually just be the licensing agencies.
That's correct.
Thank you.
Anyway, wasn't there a statute of time that a person had their fraction, okay, and it went over, it was 5 years. When you fill out an application, you don't have to disclose that you had a record before. Is it still 5 years or was it 10 years?
It's actually 7.
Oh, 7, yeah.
It's 7, and that is still in statute.
That when you apply for the license, you didn't have to put it down that you had been this fraction, okay? So after 7 years, you do not have to put it on your application. That's what I'm trying to say.
Right, but let me just say that depending on what the occupation is, there's still going to be some things that are going to show up when they do a background check, an extensive background check. I mean, it's going to be there. So, like I said, we just want to know, we want individuals up front to find out if they're even going to be able to apply for such a license so that they don't spend their time, they waste their time going through something that they'll never get.
I do believe that's everyone for this panel.
Thank you very much.
Thank you.
We have one more favorable with amendments, and that's Ryan Ross, who I believe is online. Nope, he is not there. So we will now move on to the unfavorables. We have 2 unfavorables. Janae Garwal and Matthew Disick.
Sure. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. Matt Dudzik on behalf of the Maryland Board of Physicians. You have my written testimony, but I do want to emphasize that it is exceptionally rare that the board denies an application for reasons of criminal history. If you go through the past 2 fiscal years where we received almost 15,000 criminal history record checks, not a single one resulted in a denial. The board is committed to ensuring that we have a fair and considerate process for reviewing prior convictions. And I will also add that the amendments seem to be moving things in the right direction. We've had some discussions also with the stakeholders and with the Senate sponsor. I am hopeful that we can find some areas of agreement. I did want to flag one area of concern in particular, though, and that is related to the disclosure aspect that was just under discussion. When it comes to physicians and other healthcare practitioners, it is vital that we can proactively investigate every prior conviction, even those that under House Bill 175 would not be disclosable. To quote Dr. Oshel, who is the former associate director of the National Practitioner Data Bank at the U.S. Department of Health and Human Services, patients give physicians and medical professionals the most intimate authority over their bodies imaginable. And he cautions that this authority gives them the ability to sexually abuse patients or exploit them or their insurers financially. And he also recommends that medical boards have the broadest possible latitude when making licensure decisions related to prior criminal history. Again, by removing the requirement that these be disclosed, it is limiting the board's ability to proactively investigate these. And I understand that we are still able to require a criminal history record check. And so we do still have that safeguard in place. But during the application process, we are telling applicants that they do not have to disclose a number of crimes or a number of convictions in particular that the board feels very strongly it needs to keep a close eye on for proper safety.
And sir, so let me step back a minute. So you're saying under the current law, these convictions have to be disclosed. And you're saying this law will change that?
Correct. I'm referring to the language on page 2 of the bill, where it says that a department may not require an applicant for an occupational license or certificate to disclose as part of an application any of the following. And many of the things that are no longer disclosable under this are things that would cause serious concern. I think that the most stark example would be we had an applicant in 2019 who had a sexual abuse charge that did not result in a term of imprisonment and was related to, it was an out-of-state charge where he was employed as a medical professional in a high school and he began a sexual relationship with a minor that was under his care. It did not result in a term of imprisonment. By this bill, he would not have to disclose that for 3 years. Now, I understand that we would still have the authority to take action because it relates to the profession, and I appreciate that that clause is there. But this would have said that this practitioner, when he applied to us, could have completely left that off of his application if 3 years had passed. Again, we want the opportunity to intervene in cases like that as quickly as possible. And that means starting an investigation during the application stage before we're even talking about getting to the point where a criminal history record check is received from CGIS and processed. And so that is why we have concerns with that disclosure portion.
Yeah, and I'm reading here, and I do apologize. I would have asked the last panel. So obviously they were talking about, I do believe that, some fairness that if you've been, just because somebody's accused you of something, that doesn't make you a criminal. And again, it should not be held against you. However, it does say conviction for which there is no term of imprisonment because you had a really good lawyer, or juveniles, any convictions of juveniles automatically, because you're only adjudicated as delinquent, no matter if it was for a rape or a homicide for that matter, you're delinquent. And I guess conviction for a misdemeanor that did not involve physical harm to another, like carrying a gun, things of that nature. And you're concerned with that, obviously I am too, that you may not ask for that. I was under the impression that it was basically saying you shouldn't have to tell anybody about anything that you have not been convicted of. It sounds like it's much more than that and actually goes into convictions, correct?
Correct, that's our concern.
And would you have a problem with this? Because again, I don't think that because you were accused of something that should be something that should be held against you, because honestly, it can look very bad. I mean, I have a criminal history thanks to that. And it has stopped me from getting jobs, even though there are no convictions tied to it. But you don't, do you have a problem with that as well? Mere accusations?
As far as I'm aware, there's not been a single case where a license has been denied or an adverse action has been taken just based on an accusation.
Well, let me ask it another way, sir. Now I'm gonna, maybe this is gonna solve all this. So if I come and I apply for a job and it's like, I don't disclose any of this, it still comes up, doesn't it? So all my arrests are still gonna come up, right?
Assuming that the criminal history record check is complete and accurate, then, you know, we would eventually, I hope.
No, I mean,
find out
I would pray at
down
this
the road.
point in time with all the, that's going on, that there is enough technology to make sure that you follow that. I've lived in these places. Ergo, these are the states you're gonna follow. So I'm always saying that because some of it sounds like it's somewhat superfluous to tell somebody that, hey, there's certain things you don't have to talk about when they're gonna see them anyway. And we can't, in fact, tell somebody that, hey, you can't hold that against them. Well, it's coming up. Now, I think it's like sealed in, I guess the juvenile things, they don't really come up, correct? They don't.
As far as I'm aware, juvenile convictions do not appear on a criminal
That's
history
correct.
record check.
Right.
I've certainly never seen them come up.
Right, and the same with anything that has been, I believe you can get it expunged if it's been sealed, vacated, dismissed, or pardoned.
Correct.
But as far as any conviction with there's no term of imprisonment, you still gonna see that. Any arrest you're gonna see, whether I got a PBJ, it's been adjudicated or not, you will have an opportunity. And even, I'm just concerned that we're actually making somebody look like a liar. Because I'm gonna say, look, I'm good. I don't even know anything about the cops. And then you're gonna see page after page of my arrest. And I'm worried that this bill may in fact move employers away from wanting to hire somebody with no conviction just because it looks like something was, there's where there's smoke, there's fire. And I'm definitely concerned with these convictions. There were actually convictions, I mean, unless it's been sealed, vacated, or dismissed, that means there may be an error in the conviction. Even a no term of imprisonment, depends on how much of a lawyer you can afford. So I definitely thank you for pointing that out. I do hope that's something we address. I do get the overall point of the bill, but I do think it's gone a lot deeper than just protecting people from, being disqualified after they paid for everything. Because that's what we keep talking about, but there sounds like there's much more to that. Ma'am, go ahead.
Sure. Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Janae Gorwal. I'm testifying today on behalf of the Maryland Board of Nursing in opposition to House Bill 175. And I will probably echo many of the points that my colleague has made. It is exceedingly rare that the board deny a license based solely on the grounds of a criminal conviction. In fiscal year 23, of 15,976 CHRCs, 396 were positive and 1 led to a denial. In fiscal year 22, of 11,776 checks, 306 were positive with 2 denials. The board thoroughly reviews CHRCs and considers mitigating circumstances such as age at the time of the offense. And further, applicants are afforded the opportunity to speak with the board review committee to explain the offense and mitigating factors. So although the board agrees with the spirit of this bill, we have serious concerns about it as written. This legislation would jeopardize Maryland's membership in the Nurse Licensure Compact, or NLC, as it prohibits an agency from requiring an applicant to disclose participation in a diversion program, the disclosure of which is a requirement of the NLC. If Maryland were found to be in violation of the NLC, the consequences could be catastrophic. Out-of-state nurses would be unable to administer telehealth or direct care until receiving a single state license, and the board could receive thousands of endorsement applications, which could increase processing times. In addition, to safeguard the public, the board believes it must carry out proper investigation of prior criminal history of its applicants. Certain nonviolent offenses and crimes not resulting in imprisonment, such as certain nonviolent sexual offenses, are still extremely serious when issuing licensure to nurses and related professions. The board thanks you for your time and urges you to submit an unfavorable report, although I would like to acknowledge the amendments that were discussed by the delegate. The conversation was broached today, and I know that that will be brought up to our internal policy committee this week.
Thank you. Seeing no questions, I believe that actually completes this hearing as well. Missing somebody?
Thank you.
Thank you.
Thank you. Our vice chair came back in time. So again, colleagues, we But again, I do want to make sure we do wish a hearty happy birthday to one of our wonderful members. Please don't forget when we're done to make sure you sing our guardian his happy birthday song, because I think he deserves it. You can wait till we wrap up, but I want to say, don't forget to sing happy birthday to him. Thank you. And also make sure tonight, guys, we have another event at 6 o'clock. I look forward to seeing everyone. Thank you guys very much. Thank you.